That looks fine.
We're good. Thank you so much. Hey, you want to help? I want to make sure I think
All right.
Your Honor, before we bring the jury back in, we wanted to argue the defendant's motion number 38 to exclude and remove, actually strike the testimony of plaintiff's expert Bernard Jansen. Thank you, Your Honor. This is, as I was mentioning, number 38, to exclude a specific opinion that was offered for the first time during Dr. Jansen, or I believe, yeah, Dr. Jansen's testimony on direct, that the internet video could never be removed, that it will forever be up there. In support of our motion, we've attached the initial disclosure, a supplemental disclosure, and Dr. Jansen's testimony. Nowhere contained in any of those three documents is there any opinion offered regarding the ability of one to remove any video, much less this specific video, from the internet. There's absolutely no qualification or foundation laid for that. Dr. Jansen, in his testimony of that opinion, laid no foundation for that. More specifically, in his deposition, he was asked if he intended to offer a trial, and his response was verbatim each time, that he had been asked to how many people had seen the video. Just to be sure. Another time it was asked, so you are not offering any other opinions regarding damages. His response was, I am only offering opinion about how many people viewed the video. That is a specific number. That is what the entirety of his 60-some-odd pages of reports covered. Nowhere contained therein or in his deposition did he ever offer an expert opinion that this video could not be removed or would, in his words, forever be out there on the internet. That was offered for the first time. Now, counsel, we made timely objection. Counsel asked the question 3 different ways, 3 different times. The first time, objection, withdrawn. Second time, objection, withdrawn. Went off to a topic for 3 questions, came back, asked it again, objection outside the scope. The court overruled it, and Mr. Jansen testified. That's why we were not able to anticipate Mr. Jansen's testimony until he actually tried to give it right at the tail end here before the court, based on our pleadings and what has been disclosed to us under Rule 26 in the scheduling order of this court. We'd ask you to strike that testimony from the record.
I read counsel's brief, and unfortunately there are some misstatements in the brief. The sequence of questions, answers, and objections and withdrawals of questions is significantly different than what is in counsel's brief and what counsel has just explained to the court. Fortunately, we have a daily of the testimony. I don't know if the court has the benefit of the daily, but I will be happy to recite what actually happened according to the record. The question was asked by me, last area, teach us, if you would, about getting this sort of thing off the internet. Keep it simple. Now, by the way, that question was a natural flow from the fact that it's still going on, and his supplemental report talked about it still going on, and it's a natural flow of, can you get it off? But whether it's a natural flow or not, Your Honor, there was no objection to that question. None. Contrary to what counsel just told you. The record reflects that the witness then answered, well, there's a saying that once it's on the internet, it's on the internet, and I know of no way to get it off. Just in doing continued research, people are still posting the video online a year ago, 6 months ago, a month ago, last night. So many people have individual copies out there. I don't know of any way, I can't think of any way sitting here to get it off. That was the answer to my first question. The question was not objected to. There was no effort to stop the answer. Nothing. The record is clear that it's a question and an answer. Then, counsel just said that I asked this question 3 times and they objected every time. Well, clearly that was the first time and they didn't object. The second time, the question was, will it basically, in your opinion, be on there for the rest of her life? Question mark. Objection, speculation. The court overruled the objection. The only objection was speculation, not anything about Rule 26. In fact, Rule 26 wasn't mentioned at all in the record with regard to any of these questions. But in any event, the court overruled the objection to speculation. Notwithstanding that, the record reflects that I said, I'll withdraw and ask a different question. So there was not an answer given to that question, which was the second question I asked, to which the only objection was speculation. So we go to the third question. My question was, will she have any way of getting it all off the internet? That was the question. Mr. Usury said, Your Honor, may we approach? And I said, you know what, Your Honor, I'll withdraw the question and ask my final question. And then my next question was about the fact that it's in other parts of the world as well. So here's the point. There was no objection to the first question at all. The testimony came in without objection. There was an objection to my second question of speculation only, and that was overruled, and nonetheless I withdrew the question. And then there was a may we approach about my third question, and I withdrew the question. So there's nothing that was done improperly here. All the proceedings were appropriate. The court's rulings and decisions were appropriate, and they just want to make me look bad. And that's not fair.
Your Honor, I have the transcript here. I've highlighted it for my own purposes. And as is the case in several instances, Mr. Boylett simply stopped reading where he wanted to stop reading. But let me start at the beginning. The question he asked that started this whole issue at the end of Dr. Jansen's testimony was, last area, teach us if you would about getting this sort of thing off the internet. Keep it simple. Now the question was, can you get it off the internet? It implies a present indication. Nothing about the question indicates that this is for time infinite or for the next 50 years. The question was simply, can you get it off the internet right now? And he provides the answer as Mr. Boylett indicated. That's not the first question. The first question is what followed. Will it basically, in your opinion, be there for the rest of their life? Objection, speculation, overruled, withdrawn. Next question. Will she have any way of getting it all off the internet? Your Honor, may we approach? At this point, I am asking to approach the bench to talk about how this is not contained within any of the expert disclosures or his deposition. That's the second question, not the third. It is immediately withdrawn. That is not the last question that Mr. Boylett asked Dr. Jansen. Quite contrary, the deposition or the transcript goes on for another page about other areas, and then at the very end, and in your opinion, will it ever come down off the internet? Objection, Your Honor, this is outside the scope. Did I say Rule 26? No, but is Mr. Boylett indicating that he didn't understand what outside the scope was when he knew full well what his expert had disclosed in 2 supplemental reports in a deposition? The key is this was never contained within any disclosures or the deposition. The very purpose of disclosures and the deposition provided of an expert is for us to be able to be aware of the opinions. This is not an instant. I know I've said this previous to the court. A disclosure is that, a disclosure. It is not on us to pull from him, the expert, what his opinions are going to be. They are required to be disclosed to us. This opinion was not disclosed prior to the very end of his testimony. Objections were laid to all three questions that brought in this permanency that the plaintiffs are trying to backdoor in through Dr. Jansen. Proper objections were laid at the speculation point. He had not laid a proper foundation for it. At the second time I asked to approach to address these very issues, the question was withdrawn before we could approach. On the third time, I brought up the scope of Mr. Jansen's testimony, and the court overruled it. Having gone back and read the transcript, and having gone back and gone through the two reports and his deposition, we hereby file this motion asking the court to strike that testimony as it was not contained with any expert disclosure.
The court will deny the motion to strike testimony of Dr. Jansen. This is a reasonable extrapolation or extension of his Rule 26, regardless of the motion during the question period where there was objections. So let's move on to trial. See?
Good morning, Ms. Andrews. Good morning. Good to see you. I want to start, if I could please, and see, will you agree with me on this? This is a lawsuit filed by you against my client, Mr. Barrett.
Yes.
Okay, let's talk about that. A lawsuit, you would agree, you've made claims against my client and Mr. Barrett, correct?
Yes.
And you're seeking money in those claims, right?
Yes.
My clients dispute that they're liable to you, right?
Yes.
So you would agree with me that we have a disagreement.
Yes.
So we're going to talk through and see what we agree on and what we disagree on. But what I'm going to do is break it down, because you've got the lawsuit against my two clients, but there's also one against Mr. Barrett, who's invisible in here. So we're going to break it down, and we're going to talk about both of them. I'm saying this so you don't think I'm trying to trick. We're going to start with Mr. Barrett. We will go later to my client. You've got plenty of time to talk about that before. Starting with Mr. Barrett. First, are you a victim of a crime?
Yes.
We agree on that. Is what Mr. Barrett did to you a crime?
Yes.
We agree on that too. Why do you think there are criminals in this world?
I don't know.
would you agree with me that criminals are people that want to hurt people or to take things from people? Can we agree on that?
I'm not at liberty to say. I don't know.
Well, there may be other reasons, but can we agree on that much?
Can you repeat your question,
Sure.
please?
That criminals are people that want to hurt people or take things away from people.
Yes.
On September 4th of 2008, could you ever envision someone like Mr. Barrett doing to you something like what he did to you?
No.
Do you think that there is anybody in this courtroom on this planet that thinks less of you because of what Mr. Barrett did to you?
Yes.
Who do you think thinks less of you?
Names, I don't know, but I read about it every day.
That people think less of you?
Yes.
Do you think there are people around this world who think more of you because of what happened to you?
I think standing up to the Marriott.
For standing up to the Marriott. What is the Marriott?
They gave my information to Mr. Barrett and
We're
put
going
him
to
next to me.
We're going to go to that in just a second. I'm sorry, Your Honor. Right.
What was your question?
I asked who the Marriott was, and you answered they gave your information.
The Nashville Marriott put him in a room next to me and never called and asked me if that was okay.
Okay. And we're going to get to Marriott in just a second. I told you you'd have all the time in the world to talk about that. But staying with Mr. Barrett, do you agree that there are people that think better and more highly of you because of what Mr. Barrett did to you?
No.
You don't think there's anybody who thinks higher of you because of what he did to you?
No.
The girls that you talk about in your direct testimony that say they want to grow up and be like you don't think they think higher of you?
Because I'm a victim of a crime?
And what you've been through?
I didn't understand that's how you asked it.
Well, given that we've now had this clarification, would you agree with me that people think higher of you?
Can you re-ask the question?
Sure. Don't you think there are people in this world that actually think higher of you because of the way that you have handled this, what Mr. Barrett did to you?
The way I've handled all of this, yes.
All right, so we agree on Mr. Barrett. He committed a crime. He is a criminal. In fact, you saw his guilty plea. You were there for that. You testified to it.
Yes.
Right. Actually, can you see that? I apologize.
I can.
Okay. Can you read my light?
Yes.
Okay, more important question. All right, you just talked about what the Vanderbilt Marriott did to you, that they released information about you and put them in the room next to you, right?
Yes.
Let's talk about that. You talked about with Ms. Brolette on the direct testimony, what all the people have testified over the last week said about what happened, right?
Yes.
You saw testimony from Mr. Barrett. He said that he never said your name to anybody at the Vanderbilt Marriott. Did you see that?
I didn't. I left the room.
That's right, I'm sorry. Do you agree, if he said that that's the truth?
No.
If there is a woman at the Vanderbilt Marriott who's going to come in here and testify, who works at the front desk, who testifies that he never said your name to her, would you say that's untruthful?
Yes.
You did sit through the testimony of Renee Bonacontri, right?
I did.
She's the vice president of Marriott for reservations at the time.
Yes.
Ms. Bonacontri testified that it's possible that Mr. Barrett contacted Marriott International to inquire whether you had a hotel at the Vanderbilt Marriott, right? Remember that?
I don't remember if she said Marriott International, no.
If she did testify to that, do you think that was untruthful?
No.
So you agree it's possible he called called the Marriott International to confirm whether you were staying at the Vanderbilt Marriott on that day?
I know what I was told by the FBI.
Well, my question is, are you saying what she said under oath in this courtroom is untruthful? If you don't know, that's fine.
I don't know.
You heard her testify that he called, there was a second call, to put a perspective for you. I'm really not trying to trick you in practice, trying to find out where we agree and disagree, because there are certainly agreements and disagreements. Got that?
I got it.
Okay. There was a second call, right, that she testified to? Ms. Bonacontri?
I don't remember, I'm sorry.
If Ms. Bonacontri testified that he called Marriott International to reserve a room, and that Marriott International took that call, do you have a reason to dispute that?
No.
If she testified that in that call, Mr. Barrett said, I request room next to Erin Andrews, and that request was made of Marriott International, do you have a reason to dispute that?
No.
If Ms. Bonacontri testified that the woman that worked for Marriott International, Tima Baker, you heard her testimony.
I did.
If Ms. Bonacontri testified that Tima Baker, one, worked for Marriott International, do we dispute that? Is there any reason to dispute that?
I'm still lost with your question, I'm sorry. Can you
Sure,
repeat
and
it?
do that anytime.
Okay.
Please. And I'm being sincere. Please have me rephrase that, and I'll
Okay.
do that. If Ms. Bonacontri testified under oath that Tima Baker worked for Marriott International, do you dispute that?
No.
If Ms. Bonacontri testified under oath that Takima Baker took that reservation that Mr. Barrett made, do you dispute that?
No.
If Ms. Bonacontri testified that Takima Baker took that reservation, put it in the Marriott International system, but put it in the wrong field, the information field, instead of the S field, would you disagree with that?
No.
If Ms. Bonacontri testified that by putting that in the I field, that the local franchise hotel could not see that, would you disagree with that?
I do disagree with that.
Tell me why.
Because we heard in court that the local Marriott has access to the Marcia in the back of the office. This is what we heard. And they could have gone and looked to see that I was there.
Okay. If it's in the I field, as Ms. Bonacontri testified, and that the I field would only show up in the Marriott International system, do you disagree with that?
I don't even know what an I field is. Sorry.
So then you do or don't have a reason to disagree with that?
I don't even understand the question.
If Ms. Bonacontri has testified that it went into a field that was for information purposes only within Marriott International, are you saying that her testimony was truthful or untruthful?
I don't know.
Okay, fair enough. You heard Mr. Strachan testify,
I did.
and Mr. Strachan was then the head of housekeeping for the local franchise hotel, right?
Yes.
He became the director of operations, right?
Yes.
And now he testified that he is the general manager at Holiday Inn here, right?
Yes.
Remember that? If Mr. Strachan testified, do you remember looking at the screen with the information? I don't remember the exhibit number now, but do you remember looking at that up on the screen when Mr. Strachan was testifying?
Yes.
If Mr. Strachan testified that what was on that information that went to that Marriott front desk from Marriott International was a reservation request by Mr. Barrett. Would you disagree with that?
I'm already lost with the question, I'm sorry. I don't know the computer systems or any of that.
If Mr. Strachan testified that what was presented here in this court is a copy of what Mr. Barrett's reservation request was that went through Marriott International and sent to the Marriott franchise here, would you disagree or do you dispute that?
I agree.
Mr. Strachan testified that on that request, Mr. Barrett asked for a king room, right? You remember that?
I don't, sorry.
If Mr. Strachan testified that that request by Mr. Barrett was for a king room, do you dispute that?
I don't remember. I just remember the adjoining and connecting room.
If Mr. Strachan testified that the room next to you was 2 double beds, do you dispute that?
I remember him saying that.
If Mr. Strachan testified that that local franchise hotel would not have put Mr. Barrett in a 2 double bed room when he had a king request, do you dispute that?
I do.
Why is that?
I don't think he cared what bed he was in. I think he wanted to be in the room next to me and they let him do it.
Okay, we'll get to that in just a second. What I'm saying is that before Mr. Barrett, we're going to walk through this slowly.
Okay.
Before Mr. Barrett got here, and on that reservation request was a king bed request room. And Mr. Strachan testified that the local franchise would not have put him in a double bedroom based on that request. Do you dispute what Mr. Strachan said?
Didn't we also hear, though, if you're a silver in the Marriott's reward system, you already get a king? That's what I remember. I don't remember him, but I remember that in his testimony.
Well, what he testified to, he had a guaranteed king, right?
Right, I remember that.
And based on him having a guaranteed king bedroom, they would not have assigned him a double bedroom next to you. Do you remember that?
I remember him saying that.
Are you saying you're not truthful with that?
Yes.
Why is that?
Well, I don't think it mattered what kind of bed he was in. I know he just wanted to be next to me. They told him I was there, and they put him next to me.
So that gets me back to the other question. If Mr. Barrett testified that he never used your name, are you saying that he wasn't being truthful?
Yes.
If Mr. Barrett has testified that, from his opinion, obviously the jury will ultimately decide this case, so I'm not taking that away from the jury. But if Mr. Barrett testified that no one was responsible for this other than him, you disagree with that too?
Yes.
But you do agree Mr. Barrett is responsible?
Yes.
I think the record is clear on this, but just to make sure, you know that Mr. Barrett stalked you at another hotel before one Marriott franchise, right?
Yes.
In fact, he stalked you at 2 prior hotels before the Vanderbilt Marriott, right?
Yes.
And he filmed you at another hotel prior to the Vanderbilt Marriott, right?
Yes.
And he filmed you at it was the Blackwell Hotel, right?
Yes.
And he filmed you at the Blackwell Hotel in February of 2008. You were covering an Ohio State basketball game. You haven't even recall that at all, right?
I covered a lot of Ohio State basketball games.
In the context of what happened in this terrible case with Mr. Barrett.
I don't try to focus on dates that this happened to me.
But the incident, would you agree with me, the incident at the at the Blackwell Hotel in Ohio was before the incident at the Marriott here in Nashville?
Yes.
And Mr. Barrett has testified in this case that were some 10 to 15 other women that he also stalked and take video from. You're aware of that?
I didn't read his testimony or watch it.
So you've not heard that?
I have heard some figures, yes.
Were those the right figures you heard?
I heard 14.
In a lawsuit, let's see, again, gives back in context. In a lawsuit, you have a party who's a plaintiff who sues the defendant, right? Or defendants, like in this case. We agree on that?
Yes.
Would you agree with me also that plaintiff sues the defendants and proves that they're liable, that they did something wrong? We change the state of liable law. Plaintiff sues the defendants and shows that the defendants did something wrong, correct?
Yes.
And then also sues for money, or what we call it, damages, right?
Yes.
Okay. I'm going to switch now away from the liability. We got to give you context. We're switching to the damages, right?
Yes.
And so in the damages of the jury, we'll have to determine is what compensates you for the damages. And you've talked about a lot of things with the jury over the last couple of days. So there's a few more things I do want to bring up to get out here for the jury so they can make a fair and informed decision. In this case, you found out in July of 2009 that you had been stalked and recorded, right?
Yes.
Mr. Barrett was arrested in October of 2009, which I know it also deserves to say. I'm going to get my notes. That's nothing.
Yes.
Between September of 2009 and October of 2009, before he was arrested, give me context, based on what he testified to, you were doing terrible.
Yes.
You had talked about the media and what the media was doing during the time period, questioning whether it was legitimate or not legitimate.
Yes.
In this case, and your counsel brought up TMZ, and you talked about TMZ. There was a question about TMZ.
I don't remember, but...
That's fine, that's fine.
Okay.
In this case, did you find out that TMZ actually knew about this in January of 2009?
I didn't know the date that they found out about it.
But they knew about it before July of 2009.
I didn't know the date that they found out.
Do you know what it was before July of 2009?
I do know.
And it was before July of 2009, right?
Yes.
Have you since found out that TMZ, after July of 2009, waited until late September, early October 2009 to give the FBI Mr. Barrett's IP address?
I heard that.
What do you think about that?
What's your question?
What do you think about that? Does that upset you?
To be honest with you, the only thing I think about is the fact that they were able to give the IP address to the FBI, and that's how we found Barrett, and that's how we found the Nashville Marriott. That's all I think about.
Hadn't you, maybe I wrote this down, I thought that you had already identified, based on the jeans that you were wearing, that was at the Marriott Hotel.
That's where, you're correct, yes.
All right, so Marriott Hotel had already been identified before October 2000.
In my mind, and then that's when they found him and they went to the Marriott and they got his record and they saw he was next to me.
And to your knowledge, are you aware that the local franchise hotel worked with the FBI find out what happened? You're aware of that?
No.
You had testified about the media and what the media did during that time period. You mentioned the New York Post and how terrible that made you feel with the cover of the New York Post.
Yes.
Did you ever contact them to ask them why they did that?
No.
And then you had talked about Fox News and what they did. What did Fox News do?
They played the video on their broadcast.
It was modified, I hope, wasn't it?
There were bars over my body parts.
And then we had taken your deposition some months ago out in Malibu. Remember that?
Santa Monica?
Santa Monica, I'm sorry,
Yeah.
Santa Monica. And you had talked about Bill O'Reilly particularly. I'm sorry. Is that right?
Yes.
What was it he did?
This was all the media saying she's just doing this for attention.
Is that what he said?
I don't remember what he said, sir.
Did Marriott ever put out a story about you during that time period?
I
About Marriott franchise here.
wasn't paying attention to what the Marriott was doing.
Now, Mr. Barrett was caught in October of 2009, correct?
Yes.
And he pleaded guilty in July of 2009, correct?
Yes. Wait, pled guilty in July?
Did I say July?
Yes.
December, I'm so sorry. That's okay. Do that again. If I do that, you'll correct me. December of 2009.
Okay.
So
Yeah.
he was caught in October of 2009, right?
Yes.
And obviously he couldn't plead guilty before he got caught, but caught in October 2009, pleaded guilty in December of 2009. Right?
I don't even remember the dates.
Does that sound about right?
Sure. Yes.
You were there though.
I was.
And then you had talked about Ms. Comstock that you went to see. You went to see her the first time in probably March of 2012, right?
If that's what the records are, my dates are awful.
Does that sound about right?
Yes.
If she testified to that, you wouldn't see.
I trust her.
And if she testified that you last saw her in April of 2013, you wouldn't dispute that, right?
No, that's correct.
So, the first lawsuit that you filed against my clients here in Tennessee was in July of 2010, correct?
If that's what you have.
And that one was dismissed by you. You elected to dismiss it, right? Which is fine, that's your right under the law. No problem.
Objection, Your Honor. That implies something that the court knows is not accurate.
No, Your Honor, I'm not trying to imply anything. It's her right under the law to do that. Probably.
So far, legit.
It was
That's as far as I'm going. And then that was dismissed in December of 2010, right? You recall about?
I don't recall, I have to be honest, I don't recall any of this. In my mind, I was just working, and
Okay.
if this is what was said, sure.
Okay.
Let's just worry about football.
Then you refiled this suit that we're in here for now in December of 2011, right?
Yes.
And then you saw Ms. Comstock in March of 2012, right?
Yes.
And so you talked about that you waited, that's almost 3 years from the discovery of Mr. Barrett until you saw Ms. Comstock, right?
Yes.
And you talked about the reason for that, right?
Yes.
You've talked about the stresses that you've had. And again, I want the jury to have all the information for the jury to make its deliberation. So I'm going to add a few more things. You talked about the stress that this has created. I just want to talk about a few more things. There were death threats made against you on the Dan Patrick show since this happened with Mr. Barrett being arrested and convicted, right?
They weren't on the Dan Patrick show, no.
To the Dan Patrick show.
We had heard about letters sent
And you saw your counselor for that, right?
No, I was doing Dancing with the Stars.
No, you talked to your counselor about the death threats that were made to the Dan Patrick Show, right?
Yes,
There had also been a Twitter feed with a death threat against you since then also, right?
yes,
And you talked about your boyfriend, Mr. Stoll. He got injured and had surgery. That upset you a great deal. You talked to your counselor about that, right?
yes,
And then also Mr. Stoll got arrested for drugs in Las Vegas. And you talked to your counselor about that, right?
yes,
That was very upsetting. Things have happened since the lawsuit was filed, right?
yes.
And they've all been very stressful.
Not compared to what happened at the
That's
Marriott.
fine.
But yes,
And with respect to your career, when this happened in July of 2009, you were working for ESPN. I'm sorry, when you found out about this in July of 2009, you were working for ESPN, right?
yes,
After that, you got a second contract with ESPN, right?
yes,
It was a better contract than you had the first time, right?
yes,
After that, you got a contract with Fox Sports, right?
yes,
And that was a better contract than you had in your second contract with ESPN, right?
yes,
Since July of 2009, you've also done endorsements, right?
yes,
You've done endorsements for True Biotics, right?
yes.
I saw those. Very good.
What?
I said, I saw those ads, were very good at the top of that.
Um,
You also got an endorsement for Reebok.
yes,
You also got an endorsement for Degree Antiperspirant.
yes,
You also got an endorsement for Diet Mountain Dew.
yes,
You also got an endorsement for Florida Orange Juice.
yes,
You also got an endorsement for Physique 57.
yes,
You also got an endorsement for SK Energy Shots.
yes.
You also got recent endorsement for Victoria's Secret.
No,
It's not recent,
it's not an endorsement.
I guess in a commercial.
Yes, I was playing a head coach.
I'm sorry, I saw the commercial. I didn't know what was an endorsement or not.
No,
You have an endorsement for Gillette Shave Gel?
No.
What is that?
I didn't have one
Did you
first.
appear?
No. Oh, yes, for men's shaving, yes.
And then you were the host of the 2015 CMT Awards,
I was.
and you worked the red carpet at the Oscars you talked about.
Yes,
You were on the PayPal Twitter contest during the Super Bowl 50,
I was.
and also Ladies Night Out at Super Bowl 50.
Yes,
Your income has gone up substantially since this occurred.
Objection.
Correct.
Order in limine.
Now, may we approach?
I'm already with it. I'm not with it. I'm already with it. It's a study. We're looking for. Continue.
May I approach and to inquire of the court a question? Let me ask you this question. You have done very well in your career since 2009.
yes,
You've thrived in your career since 2009.
yes.
That's all I have, Your Honor.
Just one thing. when we showed the over 4 minutes of the Nashville Marriott video to the ladies and gentlemen of the jury the other day when you were not in the courtroom, FYI, at the end of that, we showed the 6 seconds from the Blackwell. Do you see a difference in the way the social media, social world has handled this between what happened at the Nashville Marriott and what happened at the Blackwell? Explain it.
The two guys in front of Fox News, the New York Post, those were the images that they used from the Marriott. My family and I were talking about this yesterday. I left the room because I was embarrassed. And then the worst part is when you guys walked past me after you watched it, I was like, you don't really realize how long 4 minutes is until it's your naked body, you getting dressed for a football game. So I look at the Marriott as more damaging because it's 4.5 minutes of my personal, private time, absolutely naked, that everyone sees. And the images that were used in all the papers, and the images that are sent to me, and the images that people watch are from the Marriott.
Thank you.
Nothing further.
Thank you so much.
Okay, so Jerry, we'll take a lunch break and I'll call you when you're ready.
All right. Court is in recess.
Well, we did 16 minutes.
Are we